Ms. Weisenthal, is you ready to go?
Yeah, I'm here.
Thank you. Good afternoon, all. We're now on the record. It's 1 p.m. on Tuesday, April 30th, 2024. This is a public comment hearing in proceeding number 22R-0249E, the rulemaking proceeding considering amendments to the Commission's electric rules to implement the provisions of Senate Bill 21-0072 regarding transmission utility participation in organized wholesale markets. My name is Eric Blank, and I'm the hearing commissioner for this rulemaking. The hearing is webcast and will always be live. A court reporter is transcribing oral comments for the record in real time. Written comments are also welcome, accorded the same weight as oral ones, and can be submitted on our e-filings website through our online comment form or by sending them to Dora_PUC_website at state.colorado.us. If using any of these methods, please specify the comments apply to proceeding number 22R-0249E. By a prior decision issued on February 27th, 2024, revised proposed rules were issued, intended to help find a middle ground between the competing approaches presented by the two primary stakeholder groups. Written initial and reply comments on the proposed rules were filed this month, and I greatly appreciate the continued efforts of participants to provide input. I've now been through the initial and reply comments with the team, and again, greatly appreciate the constructive and thoughtful nature of the comments. Given that I've had as many questions as answers, it has been essential to hear from all of you. I guess before we start, are there any preliminary comments or matters from the participants, or should we just jump into it? And do the parties have a structure for presenting, or should I just call on whoever raises their hand first? So I don't know if someone from the utilities or someone from the joint commenter groups can let us know where we stand. That'd be great. Mr. Taylor, you want to get us started, and then Mr. Barossa?
Absolutely. First of all, can you hear me?
We can.
My name is Joe Taylor, Taylor. Thank you, Chair Blank, for the opportunity to provide comments on behalf of the joint utilities, being Public Service Company of Colorado, Black Hills Energy, and Tri-State Generation and Transmission. Once again, my name is Joe Taylor, and I'm the Senior Director of Western Markets for Public Service Company of Colorado. I'm joined here today by Steve Denman, Assistant General Counsel for Public Service, as well as several other representatives of the joint utilities. I'll be providing very brief comments on the new draft rules that are the subject of this proceeding. As you've seen by the comments and reply comments filed by the utilities and the joint commenters, the parties continue to not be wholly aligned on our views on the rules for organized wholesale markets. In these comments today, we don't plan to reiterate our recommendations or draw distinctions between ours and the joint commenters' proposals. We have offered individually and collectively limited suggestions for further refinement of the revised proposed rules. We do have two additional thoughts on the rules themselves. First, on day-ahead markets, we appreciate Chair Blank incorporating draft rules for participation in day-ahead markets. Our view is that a day-ahead market may provide benefits to customers and is an important step in evaluating the potential for future OWM participation. As you're aware, the joint utilities are actively involved in the development of the Southwest Power Pool's Markets Plus day-ahead and real-time market. Participation in these market developments requires a financial commitment from the participating utilities well before market start. We hope to see final rules that align well with these timelines. The joint utilities have proposed some modifications to the rules to address misalignment, but guidance may be needed before the Commission finalizes these new rules. Second, regarding seams, it's likely there are going to be two wholesale electric markets in Colorado, the Southwest Power Pool Markets Plus and the Southwest Power Pool RTO West. Some focus on regional coordination has already been initiated for the development of tools to address seams between Markets Plus and the California ISO's extended day-ahead market, but it is of equal importance to explore the potential for optimization between Markets Plus and RTO West. The joint utilities are not opposed to exploration of this coordination being a requirement in the OWM. Thank you again for the opportunity to provide these comments and to answer any questions you may have.
Yeah, I do actually have a couple questions. Do you have any advice about how to capture? I mean, I've seen some rules, but would you like to expand on the best way the rules can capture and advance the discussion on seams between the RTO and the day-ahead market? Anything you'd add to what's been submitted?
Certainly, in particular, I think it's important to understand that Markets Plus has a day ahead and a real-time market, as does RTO West, but the markets aren't identical. As you know, the Markets Plus tariff started with the RTO tariff, but then has a number of modifications. And so what we call co-optimizing the real-time market between the real-time component of Markets Plus and RTO West real-time market is critical, and then in the day-ahead environment as well. So I think the primary interest we have in this, at least the initial seams coordination, is on allowing or setting up the markets to be able to trade as seamlessly as possible, recognizing that even though they're run by the same market operator, they're two completely different market designs.
Appreciate it. Mr. Denman, would anyone else like to speak on behalf of the utility group?
Thank you, Your Honor. My camera won't come on. There it is. Appreciate you calling on me. Public Service Company has no independent witness to propose, and I defer to my colleagues from Tri-State and Black Hills regarding anything further they'd like to say.
Tri-State or Black Hills, anything further you'd like to add to the written record? Mr. Sopkin, Ms. Tiffin.
Good afternoon, Chair Blank. We do not have anything further to add to the record. I would note that I'm here, and also Kathy Sabers, also in-house counsel from Black Hills, is here with regard to any issues that come up or any questions.
Thank you, sir. Ms. Tiffin.
Yes, thank you, Chair. I just wanted to add that Tri-State kind of echoes what Joe Taylor from PSCO was saying, and that it is important to us that as the markets develop across Colorado, we see co-optimization between the two markets. The SPP is already contractually obligated to co-optimize with the WICE when the SPP RTO West expands into Colorado. And it would seem a reasonable next step as utilities move into Markets Plus to have the real-time portion of the Markets Plus be co-optimized with SPP RTO West. And we have expressed our interest in that and our concern for that happening to SPP.
Appreciate it. Thank you. And any advice on how to set up a standard in the context of rulemaking that you'd add to the written comments?
I guess I would just add that I think it would be helpful in the rules to have a section or at least some kind of comments in the seams area discussing the need for that co-optimization. We know that moving to markets is a huge step for a lot of utilities and getting rid of some seams. In some cases, we're getting rid of seams between transmission providers, others just with co-optimization over a larger footprint. But we want to be wise about how we approach that and make sure we don't just create new seams that we'll have to live with for years and years. So having some language in there, having utilities having to advocate for that co-optimization as they join markets, I think would be very valuable.
Thank you, Ms. Tiffin. Anyone else on behalf of the utilities? Mr. Barroso.
Thank you, Mr. Chair. Parks Barroso, attorney with Western Resource Advocates. Today, Mr. Fanyo and I will just provide a brief presentation on behalf of the joint commenters.
That'd be great.
It's all right with you. I'll launch into that.
We're ready.
Thank you. And thank you, Mr. Chair. I'd like to start by recognizing that the joint commenters have represented a remarkably diverse group of interests. This includes groups that represent the consumer interest, renewable energy developers, electricity customers of different sizes, environmental organizations, and other public interest organizations. And indeed, the joint commenters represent nearly every active participant in this rulemaking other than the transmission utilities. And through our various rounds of comments and blue lines, we've achieved a level of compromise and unanimity that this commission encourages. We remain very supportive of the commission's intent to promulgate rules governing market entry and appreciate the commission's efforts to address all the critical issues that come with the utility joining an RTO or ISO or participating in a day-ahead market or a dam. And I'll highlight at the start that following this hearing, we believe that a commission decision issuing final rules will be an important step in influencing ongoing market development and will provide much needed certainty for the commission, for transmission utilities, and for stakeholders alike. And I'll acknowledge too that what we've proposed through the latest rounds of comments and blue lines appears to be extensive edits to the proposed rules, and hope that the commission takes the joint commenters' blue lines in the constructive spirit in which they're intended. And just now, we'll briefly summarize some of the key topics and areas of change that were addressed in our comments and blue lines, and then we'll invite any of my colleagues to provide additional detail. And we look forward to engaging in any discussion and back and forth with the commission and other parties. Regarding the rule structure and the process for the various filings contemplated, the structure proposed in our blue lines is intended to reflect the intent of the proposed rules, which differentiate a filing on two bases. The first is a differentiated process depending on whether the decision is to participate in a dam on the one hand, or to join an RTO or ISO on the other, with corresponding lessened degree of procedural requirements if the market is a dam. And then for each market filing, the substance of the filing differs depending on whether the utility is an IOU or a generation and transmission cooperative. And for each of those filings, we've suggested some rule language to put more specificity on the process to be expected. For dams, we recommend an adjudicatory proceeding, but one that is less intensive than a fully adjudicated application. This is something that would look similar to a gas infrastructure plan filing, for example, and would include the following elements: pre-filed testimony from the utility, the opportunity for comments from interveners, discovery, and a public comment hearing. The other procedures would be left open to the commission to establish when opening the proceeding, and we have intentionally left a good deal of flexibility for the pace of the procedural schedule, which could be more expedited as needed. And we'll note here that under the commission's proposed rules, the dam proceeding is one in which the commission intends to make a public interest finding about the utility's participation in that dam. And so we believe that some degree of adjudicatory process is really necessary to establish the record for the commission to make that finding. Regarding filings for an RTO or ISO, simply put, we believe an adjudicated application is necessary. The commission will be issuing a determination about both whether the market qualifies as a statutory OWM and whether it's in the public interest for the utility to join that market. And we believe that there could be serious due process concerns if the process of that filing is left unspecified in the rules, and urge the commission to provide the parties with notice by establishing the expected process upfront via these rules. And just finally, regarding the application for waiver of delay, our blue lines have removed the rule language that would require a utility to file such an application, as we view that requirement as unnecessary and restrictive of optionality. Additionally, we recommend that applications for waiver of delay not be filed until the latter part of this decade, because the requirement to join an OWM doesn't take effect until 2030. We believe the corresponding application should be closer in time to that 2030 deadline, and have recommended a January 1st, 2028 window in the rules. As a practical matter, this will allow market development to continue without prematurely seeking a commission determination that no qualifying statutory OWM is available to that particular utility. As part of both the DAM and the RTO ISO filings, joint commenters have added a requirement for the utility to present a comparative market analysis. This sort of analysis will ensure that DAM participation or RTO ISO membership will bring the greatest benefits to Coloradans. And this kind of analysis is something that's already been performed by several utilities across the West, including NV Energy and Portland General Electric. We've attached those studies to our earlier comments and believe those studies could serve as a good example and model for Colorado's utilities. Finally, on the definitions, I'm not going to walk through each of the definitional changes for the sake of time and for everyone's sanity here in this public comment hearing, but we'll note that, as reflected in our reply comments, we've incorporated a number of the transmission utilities definitional changes into our blue lines and identified several areas where the joint commenters' blue lines and new rule structure actually serves to resolve questions and concerns that the transmission utilities had identified. One of the important issues that we sought to address through those definitional changes was the distinction between the ISO or RTO that operates the market on the one hand and the market being operated. And second, we provided blue line changes to clarify that energy imbalance markets, or EIMs, and DAMs are run by ISOs and RTOs for non-member utilities. And these changes should help to clarify the market functions that are provided by an EIM or a DAM. And with that, I think I'll pass it to Mr. Fanyo for the remainder of our comments, but I'm also happy to pause for questions.
Yeah, I do have a couple. As I remember, the gas infrastructure plan was filed in an M docket, not an application. And I mean, just internally with council and advisors, we've been going back and forth about how to have sort of an expedited adjudicatory process. In your view, do you believe you can have an application process and not have, at the commission's discretion, answer and rebuttal testimony? And in your view, do we need to have a hearing with cross-examination, or can we just have a more sort of like a rulemaking hearing? So just curious if you could help me understand how much flexibility you think this commission has and how much you'd like to see in terms of due process.
Yeah, I appreciate the question. I think another example in the commission's rules that I didn't note is Rule 3605A, Roman numeral 1, which established an adjudicatory proceeding to receive a report. I think this was specific to Tri-State's resource planning filing. And I think that that is an example of the flexibility that the commission has to establish something that is more than an M docket, but less than a full application. And I think we would have concerns about proceeding under something that looks like a notice and comment rulemaking, but acknowledge that it may not be necessary for interveners to file testimony, for example, and that there may be time constraints that the commission wishes to address in setting a more expedited schedule.
And do you think cross-examination would be, do you think we could do a notice and comment proceeding like this, or do you think it needs to be full cross-examination?
We didn't address that in our comments. I think that in a proceeding where the commission is making a public interest finding, that sort of robust hearing would likely be helpful to the record. And we've seen that in dockets, without that opportunity, it can be often difficult to fully probe analyses or testimony that are filed by the regulated utilities. And so I think we would probably err on the side of a full hearing with cross-examination rather than a rulemaking style hearing like we're in today.
And would you be open to a shorter time frame
For the hearing or for the full
for the full
proceeding?
process? I mean,
For the
people are
full
going
process.
to be.
Oh, apologies.
Yeah, sorry, go ahead.
I was just going to say, certainly, I think a shorter time frame for the full process may be appropriate. And so we didn't, seek to lay out a 250-day statutory or rule deadline for a commission decision or any kind of parameters there. I think in the blue lines as we put forward, there's discretion for the commission to shorten or establish a schedule as appropriate.
Mr. Fanyo.
Thank you, Chairman Blank. I appreciate Mr. Barros's comments. I will pick up from there and address the reporting, particularly the stakeholder process and the shared savings provisions that we have proposed. As you and probably everyone else, possibly painfully, is aware, we've had a ongoing difference of opinion with the utilities for about a year and a half or so.
Trying to find the middle ground, Mr. Fanyo.
Middle ground, which is exactly what we attempted to propose in our rules 3758. Previously we had been indeterminate on the number, scope, and method for stakeholder meetings. Here we got specific, and we used the framework of the annual reports that were proposed in the most recent version of the rules as the timing framework. Every June 1, starting in 2025, the utilities are required to file reports. We use that as the point of reference for proposing a single, not multiple, stakeholder meeting in the year following each report, and proposed that it be in the third quarter because that would give time for digestion and development of questions, comments, and responses after the June 1 filing. And we mitigated, we referred the scope of that stakeholder process to the list of requirements that would go into the participation proposal. So it would cover all of the items that would be required to go into the filing to join, either to participate in or join a market. And it was mitigated, however, with the language that says to the extent reasonably available. So to the extent that plans hadn't developed, that options were still being considered, that new information was required to reach a decision, the utilities would not be required to have completed all that by the time of the stakeholder meeting. But it would be open to a post-meeting process of questions and responses which would lead at the commission's discretion. Nothing that we wanted to put in here would require the commission to do anything, which would, at the discretion, involve a commissioner's information meeting. And the idea is that the reports followed by the stakeholder process would lead to a useful discussion before the commission and information to the commission of what is going on, how things are being developed, what are the ideas that are being considered, and progressively from 2025 to 26 and 27 to a more presumably refined set of proposals and parameters. And hopefully through that process, one of our key objectives, as you mentioned, I think it was in paragraph 40 of your decision setting up this hearing, more progressive coming together of views. Now, I can't count on and almost certainly can guarantee that there would remain disagreements. That seems to be inherent in all these proceedings. But we don't need to have the first time that a filing comes to the commission be the one where everybody says, now, what's on page 6? What's that mean? What's on attachment A? We don't need that. The process of those stakeholder meetings, annual reports, stakeholder meetings, CIMs, is intended and expected, I think reasonably so, to lead to a more common understanding, possibly a considerable level of agreement on whether a particular proposal to join particularly an RTO would be in the public interest, whether it complies with the OWM 10 criteria, as well as whether it meets the additional criteria for IOUs, the 5 points, or the 2 for tri-state. That's the whole idea. Now, we consider that a compromise because it's not there's nowhere near the degree of public participation that exists in other proceedings. It's spread out over 3 years, it's focused, and it's progressive. The remaining difference is a stark difference, where the utilities believe that none of that is necessary because it's all available and possible through the various regulatory proceedings at FERC, through the various, not only the investigation and development of rules at FERC, but also with specific applications. It's also available to all the parties to participate in the various regional groups that are addressing various types of markets and various types of organizations to run those markets and various levels of participation. No question, all of those forums exist and they are open. However, none of them is focused on Colorado's interests, the Colorado parties, utilities, other interested parties, the commission, the legislature, the governor. None of them is focused on what the legal requirements that are applicable here are. And so the participation of various diverse Colorado interests in those various forums is diffuse. It's not focused. This proceeding and these sets of rules that we have proposed, including the public participation, as well as the the various proceedings for once filings are made are aimed at focusing on Colorado participants and interests and requirements. Now, as you have pointed out, and I think it's obvious to everyone who's been involved in this, to influence the decisions that are being developed and will be made on these various market organizations and how they will operate, are proceeding at some pace, and have been throughout the process we've been involved in here. The sooner that we get these rules finalized, presumably with a good deal of our comments incorporated, but whatever they are, the sooner they're finalized, Colorado and all the Colorado representatives, not just the commission, all of the joint commenters, the utilities, will have a marker that informs their own participation, how they advocate in those various forums, and well as informs the other parties that are involved in developing those rules and processes for the regional markets. Until then, we have me saying one thing, Park saying another, you saying another, and all that gets sort of diluted in the discussions that are ongoing. Not yours, probably. Yours probably aren't diluted, but certainly mine would be. And so the idea of getting these rules done is quite important. And for that reason, I know it's typical or standard to have post-hearing comments. I would suggest that we do that. Give everybody a fair opportunity, but I would also suggest that be a fairly short period of time, maybe 20 days. I want to address one other thing, and that is the shared savings issue. Our proposal has it suggests not specifying the method of calculating whether shared savings have accrued to customers, what the method for determining net present value and the other parameters of the shared savings calculation would be, but rather to give a little more detail to the list of items that a utility should present in its application for shared savings as part of its burden to prove, or actually the statutory word is demonstrate, that the net present value of savings accruing to customers. One point I want to make is that statute, unlike the comments of I believe it's Black Hills, does not mandate utilities receive a share of the net present value of savings accruing to customers. It certainly allows it, and it certainly provides for the opportunity to demonstrate why that should be done. But not only does it require demonstration of such savings and that they accrue to customers, but once that number is determined, that customers, the amount accrued to customers, a portion of that is shareable with utilities. And the share, as the statute says, can be anywhere from 0 to 35% in the first couple of years, then 25 and so forth. So there's the bottom line is there's no right to a utility participating in shared savings there is an obligation for them to bear the burden of proof as to what the savings are, how they're calculated, and how they should be shared. And then there is a requirement that the commission determine what that proof has shown. Those are my comments on shared savings. We
Thank you,
appreciate your
Mr.
consideration.
Thank you, Mr. Faneuil, and I can tell you we share your sense of urgency and appreciate pitching us on optionality. We like discretion. So thank you, sir. I guess three areas I'd like to explore with all the parties, but before we go back and do that, are there anyone else who would like to make comments? Please put up your hand. Seeing none, I guess with everybody who's spoken, turn back on their cameras, and I just ask the utilities to respond to what Mr. Barrasso said on the process. Do you think his process is outlined? It sounds like an application, maybe on an expedited frame, direct testimony, maybe not answer and rebuttal, maybe with cross and limited discovery rights on an expedited time frame. Would something like that make sense to you, or would you have concerns, Mr. Taylor or Mr. Hefner?
I'll let Mr. Taylor go first if you'd like.
And if you could introduce yourself for the record too when you do speak, that'd be great. Go ahead, Mr. Taylor.
No, I was glad a lawyer raised his hand. So
I was figured.
I was gonna defer to Mr. Hoffner.
Sure. This is Dietrich Hefner of Louis Roca on behalf of Tri-State. Just on the procedural front, especially with Tri-State's relatively near-term plans, we see a need for a procedural mechanism that is relatively brief and doesn't impose a tremendous burden or delay. I think from a legal perspective, what due process requires is notice and an opportunity to be heard. And I think there's, as you pointed out, Chair, a lot of flexibility for the commission as to how you achieve that. Certainly, we don't think that extensive testimony, whether written or live cross-examination, is necessarily required, nor do we think really very much discovery at all is required here, and we'd like to see a process that's pretty efficient and tailored to the task at hand that allows everyone to get the information they need, but doesn't impose a tremendous burden or delay.
And do you think that can be done through an application?
I think an application potentially with rules specific to this process, not the commission's default application process, which I think would just be too lengthy for what needs to get done here.
I don't know, Mr. Sopkin or Mr. Denman, can you add content? Is it just a shorter deadline? Is it limiting answer and rebuttal to sort of more of a written comments and limiting discovery and putting it on a shorter time frame? Mr. Sopkin, Mr. Denman?
Yeah, I'd agree with Mr. Hefner's comments. I think the case law is pretty clear that the commission does have a lot of discretion in terms of adjudicatory proceedings as to what process is required, as long as there's no notice and opportunity to be heard. I think there are specific rulings that say you don't have to require discovery, you don't have to require cross-examination. A comment process is sufficient for that. And I think the commonality among our comments, the transmission utilities comments, is we're trying to avoid processes that involve a lot of litigation, a lot of duplication between proceedings, and that would include for proceedings as well. Because the intent of the statute is to encourage utilities to join markets that will save consumers and energy producers money. And so I think the utilities are proceeding in good faith toward that destination. But the more that is thrown in the way of that by way of inordinate or unnecessary process, and that can include, overly extensive stakeholder engagement processes. The more that happens, the less likely that the end goal of the statute is to occur. I think our position is as simple as that.
Anything you'd add, Mr. Denman?
Yes, sir. Thank you. Early in my career, I was a chief assistant public defender, and I used to argue about due process a lot. The lesson I learned from that is the courts and the statute will give you the process that's due. And that is really the question here. I agree with what my colleagues have said. The commission needs to implement the statute in a clear, understandable way, and also paying close homage to the actual language of the statute. Our comments discussed a number of things where we believe that Mr. Fanyo and his colleagues would add things that are not in the statute that were burdensome, and I know you read all of that. As a young utility lawyer, another lesson that I learned is that if you really want to stop somebody from doing something, the best way to do it, if you're sufficiently well funded, is to add as many procedures, burdens, minimum filing requirements as you can dream up, because it will make slogging through the litigation difficult and expensive for those who are trying to do what they're doing. In this case, utilities trying to join day-ahead markets or perhaps OWMs. And so, my final advice is just be careful. Let's adhere to the statute. Do what this commission needs to do consistent with its policies and make this an efficient process. I agree that comments can suffice for a lot of filed litigated testimony. Thank you.
Mr. Barossa, you want to put back on your camera for a sec? So I guess I'm just trying to see if there's how much daylight there is between. So putting aside an IOU, and you can, Mr. Denman, Mr. Sopkin, why don't you leave your cameras on too? Let's see if we can explore how much daylight there is between you guys on this issue. So putting aside an IOU, maybe going in a full RTO for the day ahead decision for an IOU, or for a G&T going into a RTO, the two decisions that seem to be on accelerated timeframes and require financial commitments and are in this interactive regional and FERC jurisdictional process. Is there an application that could occur in, say, 4 months, 120 days, that is, maybe pre-filed direct comments from the parties, limited discovery, on a day hearing that would get some decision relatively quickly? So I don't know, Mr. Sopkin, I see you cringing. Maybe, so I just, Mr. Sopkin, Mr. Barossa, is that inconsistent with how you were thinking about it, Mr. Sopkin?
It's very much devil in the details territory as far as, what does limited discovery mean? What does, what sort of exact processes would there be? Is there a way to design a process that's a rocket docket, as they say? Yeah, there probably is, but I would hope that the rules would be set out in a very clear and limiting fashion to accomplish that end.
And can you suggest what would the elements of those rules that limit and constrain the process? I'm suggesting like a tight deadline, limited discovery, very limited or no answer and rebuttal testimony, just pre-filed direct. Are there elements you could help steer us towards, or are you just against an adjudicatory sort of application process?
Well, in terms of what does the word adjudicatory mean? I mean, yes, it's more judicial than legislative, and what I was
I
suggesting.
mean, an application.
An application, yeah. I don't have, a set of rules drafted on what this animal would look like, but in terms of a filing with, here is what must be addressed in the filing, and you should set forth a witness and an application on this, and then parties are allowed a limited set of discovery about that, including subparts. Certain number of questions has to be responded with in a certain number of days, and then parties can file one type of one set of response comments, or however you characterize it, to that, and then a quick hearing to follow. That's the kind of process that could happen. I'm not saying it's something I recommend. I would prefer, much more of just a comments and response process. But yes, could that be devised? I do believe the commission has competently done so in the past.
Mr. Hefner and then Mr. Barrasso.
Yeah, so I'll agree with Mr. Sopkin on his last point, that I think we see an opportunity here maybe to forego witness testimony altogether and have the focus really be on the application filing, maybe some amount of limited discovery, and then responsive comment filings, similar to the back and forth that's happened here, but maybe without the more elaborate mechanics of testifying witnesses and cross-examination and all that goes with that. I think once you have witnesses testify on direct, it becomes hard to avoid having witnesses testify on answer and folks wanting cross-examination rights. But certainly there are many types of administrative proceedings where the application is truly just an application, either signed by counsel or signed by counsel and verified by somebody within the company. I think you do have some flexibility to avoid some of the complicated mechanics that can cause proceedings to last longer.
One more question, then I'll turn it to Mr. Barrasso. And you think you could do that in an application?
Yes.
Mr. Barrasso, would that address your concerns?
Thanks, Chair. I guess I'll just start by saying that I'm speaking on behalf of WRA now. I think there's a lot of joint commenters that might have nuanced views on this, but I think what I'm hearing sounds like good progress. I'm hearing my colleagues from the utilities agree to some sort of condensed application filing. I think some of the concerns are easily mitigated. For example, that folks might want answer testimony. I'd point out that in our rules, we explicitly provided for comments from interveners, not rounds of answer testimony. And so that procedural addition would be mitigated if you just have pre-filed testimony from the transmission utility that's filing.
And they're saying it's not even pre-filed direct. It's more like an application with a sworn affidavit, something like that.
I think that there are compelling reasons to consider the value of pre-filed testimony. We were talking about a significant step for the state's utilities and something that many of the groups, WRA included, are supportive of them taking. The burdens, to my mind, when you know that you have a condensed schedule, the burden of having testimony versus comments feels incrementally not that much more. And in terms of the urgency that's being discussed here, I think it's important to differentiate the utilities that have more near-term commitments from those that don't, and whether the rules could respond to that. You noted that Tri-State, for example, is further along in their process to join a day-ahead market, and so, or to join an ISO or RTO, apologies. And just finally would note that I think if we're talking about the commission making a statutory finding that the market qualifies as a statutory OWM, that is a finding that will likely benefit from sworn testimony. We hope that this kind of proceeding is also something that can be viewed as an insurance policy by the utility too. We are ideally going to end up with a commission decision finding that it's in the public interest for them to join a particular market. And so to the extent that you have a robust adjudicated proceeding that has yielded that decision, I think that that's in the interest of all parties.
The second issue I think you and Mr. Fanio raised was a comparative analysis. Mr. Taylor or the attorney's comments on conducting that analysis. I know the Western Meg study did have an EDAM bookend that did do some comparison of the markets. Mr. Hefner, Mr. Taylor, and then back to you, Mr. Barroso.
Yeah, thanks, Chair. I think we'd look at the suggestions around a comparative analysis against the text of the statute. And we see the statute as essentially setting the bar or the floor for what qualifies as an OWM. And once you qualify as an OWM, that's the end of the inquiry. And I know we have a disagreement with the joint commenters about sort of how the statute should be implemented and the extent to which it limits commission authority. But I do think it speaks, regardless of that disagreement, I do think it speaks pretty clearly to the notion that once you satisfy those 10 criteria, you're an OWM, and joining that market by 2030 satisfies the statutory command. And so we would see adding this additional layer of comparison as A, unnecessary, and B, contrary really to the scheme the General Assembly set up, certainly with respect to an OWM, but also with respect to a day-ahead market, which really isn't discussed in the statute at all.
Mr. Taylor, then Mr. Barroso.
Thank you, Chairman. You're right. The Western Meg study had everybody in the EDAM in one of the footprints. We and Tri-State and the other utilities on this call focused on different markets plus scenarios in the other footprints because in part because of the leaning that was taking place at the time of Tri-State and Western and the other utilities going into the RTO and the need to stay with our neighbors as much as possible. The additional comparative analysis that the joint commenters presented, we haven't done that study. They mentioned NV Energy has done that, Portland General's done that. I think PNM in New Mexico is starting that process to hire a different consultant to perform related studies like those. If I remember right, those contracting for those studies and scoping them out was probably a year ago, and the results have just come out. The commitment to enter Markets Plus for us is, at least at this point, is end of this year. So getting a study performed that would satisfy the comments by the joint commenters, I think, would put us a year out from today, before even being able to provide whatever adjudicatory process we took.
Mr. Sopkin, then we'll go to you, Mr. Barroso, and if you want to phone a friend and get some help. So go ahead, Mr. Sopkin.
Yeah, I just I really support the comments from Mr. Taylor in particular. It's a very expensive, time-consuming process what is being considered here for us to sort of examine the universe of comparative markets and provide that detailed level of analysis and modeling that has been requested. And the other thing I would emphasize is it's a snapshot in time. We all know that these markets are evolving almost on a daily basis. And so I guess I question the value of something that could change significantly over time.
Why don't you jump in, Mr. Barroso? Oh, you're still on mute.
I got the hand, but not the mute button. Thanks, Chair. So I will see if my colleague Nancy Kelly is on to address this, because this is something that she has a lot of expertise in, but would just note at the start that some of the practical concerns that have been raised feel like addressable concerns, and to the extent that we're concerned about this not being an end-all be-all analysis that reflects market developments in coming years. I think that is true of all analyses, and we're talking about something that reflects the best available information to utilities and other groups at the time of completing that analysis. And it's likely helpful information for the commission and for stakeholders to have available to it.
Ms. Kelly?
I see that Ms. Kelly has her camera on, so I will stop talking. Thank you.
Good afternoon, everyone. Thank you for the opportunity to address this question. We do believe that the comparative analysis is important. The WMEG analysis had the Colorado utilities in Markets Plus and in RTO West in the analysis, and they were never included in the EDAM. So you don't have in front of you any analysis that shows the benefit to Colorado from going in a different direction, because, as you say, the utilities have been moving in this direction. But by 2030, there could be two RTO ISOs that could qualify as an OWM. And then the question is, which really brings the greatest benefit to Colorado and Colorado's customers? And that will depend very much on the footprints and who all is in and who is out. And so this type of analysis, I think, is important. The Brattle work is different from the WMEG work as well, in that the one was a zonal look. That by that I mean that you're not looking at all the congestion within the zones. And so, for example, Public Service in their description of their WMEG results talked about the disconnect from reality and all the changes they had to make. Well, part of this is because it wasn't showing the internal congestion. And so the type of analysis we've also requested be done would be a nodal analysis that would be able to look at that internal congestion and give you a better feel of what the potential benefits are to Colorado customers from different market designs. And this work has proceeded quite a distance now. Brattle is the consulting group that has been working and developing the same group that the commission hired to do the study, and a lot of that background work is ready to go. So I am not at all, I don't know if it would take a full year and slow things down by a year. I think that that's important information to have and look into, because I think there are great benefits to understanding the implication of different market designs and how it could affect customers based on who's in and who's out of the market. The larger the market you have, the greater the diversity, the greater you're going to be your benefits. And you know, we certainly see that from the types of results that are coming in from the markets. And I believe that there are probably others that would like to speak to this. And so thank you for the opportunity.
Thank you, Ms. Kelly. Mr. Turner, if you could introduce yourself.
Sure. Good afternoon, Chair. Brian Turner, Advanced Energy United, and Ms. Kelly incorporated many of the comments I'd like to make, but I think I'll make them anyway, just with a different face and voice and perspective. So Advanced Energy United is very supportive of market entry by the Colorado utilities. So I hope that we can do away with the argument that the process that we're talking about here is one that is meant to stymie that entry. We are fully supportive and want to see the Colorado utilities join the market that is best for the Colorado public interests. In particular, of course, our organization is concerned with the clean energy interests of Colorado businesses, consumers, and state policy. And I mainly wanted to point out in reference to this question and the previous one that the questions that your proposed regulations outlined and that we refined in our comments are knowable questions. They are technical questions. They are economic. They are engineering. They are accounting. They are environmental questions that are satisfied with evidence and argument. But they are less, as well as policy arguments. But the technical nature of them needs to be interrogated. And so that in reference to the process here, I'm not an expert in Colorado PUC proceeding process, but we would like the opportunity to question, interrogate some back and forth with technical experts on those public interest objectives that of a technical nature, the GHG accounting in particular, the resource adequacy construct, the use of transmission, the resources that would be available to the market and would be dispatched, the seams question and the market efficiency of those seams, all those, again, technical knowable questions that we would like the opportunity to interrogate. And then on the question of comparative analysis, I just wanted to point out that in other spheres of commission oversight, comparison is critical to determining the prudency of investments, for instance, and the or in the language of the statute, to the extent reasonably possible. Reasonably possible is one key determination there is what else is available. So that comparative analysis, I think, is a key ingredient into determining the adequacy of a proposal. And I think that about captures it. Thanks. And I'll just echo the point about the nodal analysis. That's also something that would, and to the point of the Brattle study specifically, not that the utilities need to choose the Brattle study, but the 1-year contracting timeframe was brought up. That was, they constructed a special model for that with the nodal construct of the Western interconnection and the different market footprints. That model has been developed. So I don't know that the time frame from the previous constructing the model is necessarily indicative of what it would take to run the same model again for this context. Thanks.
Any other comments? I know you had your hand up, Mr. Denman.
Sure. As to both on the comparative analysis issue, I agree with my colleagues, Mr. Sopkin and Dietrich. The other thing I would suggest to Your Honor is that the Supreme Court held long ago, after the commission litigated what was called the Public Service Company emergency electric rate case, that you've got the authority to truncate procedures and to shorten discovery and control your process so that you can efficiently get done whatever it is you need to decide. So I don't think that's a big problem for the commission. In crafting your rules, though, if you decide to adopt rules that are different than the standard application rules that exist in the rules of practice and procedure, please make it very, very clear that that's what you're doing in these rules, and those special procedures, truncated or not, apply to whatever filing it is you decide you need to use in this case. That way, none of the participants, utilities, those opponent interveners, will be confused about what it is the procedure is that's going to be used in this kind of proceeding. And that way you satisfy one of the critical requirements of the Administrative Procedure Act, that your rules have to be clearly stated as far as practicable, so that those who have to comply with them understand what your rules mean and how to implement them. And I agree with the comments made by my colleagues in Black Hills and Tri-State on other matters. Thank you.
Thank you. Is there anyone else who would like to share comments?
Mr. Chairman.
Yes.
Good afternoon. Just briefly, on behalf of the Clean Energy Buyers Association, I'd just like to second what Mr. Turner said, that we certainly support the utilities joining markets. Generally, we do believe that this process is important, but it is certainly not there for the purpose of delaying needlessly or preventing that ultimate outcome.
Thank you, sir. Anyone else who'd like to make a comment? Well, I greatly appreciate the constructive and thoughtful nature of both the comments and the discussion today. I've learned a bunch and have given us and our team a lot to think about. So thanks to all for that. I'd also say I was really pleased to see the general agreement among the parties on modifying and improving the definitions and incorporating each other's changes. I think that makes the rules clearer and more appropriate. I'd also say my biggest struggle in this proceeding has been to adapt our rules to treat different market structures and types of utilities based on the individual characteristics of each. And I was really relieved to see that this segmentation receives substantial support from the parties. I also appreciate the joint commenters' proposed restructuring of the rules to explicitly reflect these distinctions. I also agree with the utility and comments earlier today, and something the joint commenters put in their comments about the importance and potential concerns with seams issues even within Colorado, if one utility is in the RTO West and another is in the day-ahead markets plus, we really don't want to go backwards from where we are in an energy imbalance market if it ends up that way. So thanks to the parties for flagging that issue and creating a record to make sure we get that addressed going forward. I continue to struggle with the interconnection queue issues. I know SPP is making progress in reducing the backlogs in the prior queues, but for me, that's a symptom of the problem. The real problem is that there's no way in these RTO queues to prioritize projects based on location, timing, resource type, and the queue continues to grow. I think the SPP queue is now 50% greater today than it was a year or two ago. So I think we need to continue looking at that. And progress isn't defined by eliminating the backlog. Progress is defined by being able to prioritize among the projects. Other than that, we're trying to create a workable process that tries to give people a fair opportunity to comment in a way that meets the timing concerns and is sensitive to the fact that a lot of this is for jurisdictional and a lot of it involves utilities that we have no jurisdiction over. So it's just an inherent balancing act, and I think we're struggling to find the middle as best we can. Finally, it would be my intent as the next step to quickly develop another set of rules reflecting the comments and discussions that we've heard, both written and oral today. And these will be issued with either a recommended decision or another request for participant comments. But I would just echo Mr. Fanyo's comments about the urgency of getting a clear process defined in a timely way, given Mr. Taylor's comments that financial commitments are going to be made, as soon as, the end of the year. So that's what I have. I don't know if there's any final comments before we go and recess the process. Is there anything anybody would like to say? Mr. Hefner.
Yeah, if I could, just in light of the, some of this discussion around procedures for day-ahead markets, I think from Tri-State's perspective, one really important fact is that Tri-State is not a balancing authority. And so to the extent that its load in PSCO, for example, were to go into a day-ahead market, Tri-State wouldn't have really control over that. And I don't know that we have the solution for you today, but certainly a factor to keep in mind that Tri-State more or less has to go where its balancing authority goes. And that's a complicating factor for all of this.
As I understand it, Tri-State's in 4 separate balancing authorities, 2 WAPA ones, one on the east side of the synchronous divide and the Xcel Energy one. So
we hope all of this will result in fewer seams, not more.
Amen. Exactly. Any other comments? Does council, PUC council or PUC advisors have anything? Ms. Rosati, have I covered all our bases?
Yes, nothing from me, Chair.
Okay. All right. Anything else for the conversation today? All right. Thanks all for the discussion. greatly appreciated. And like I say, we'll drive these rules as quickly as we can. So thanks
Thank
all.
you. Thank you.
Thank
Chair
you.
Blank.
Thanks.
Thank you.